Please, Your Honor. Your Honor, I beg to mention item number 24. I am for the appellant.
Okay.
I have taken consent from the other side also, my lord.
Asking for adjournment. When do you want?
After 2 weeks, my lord.
On what ground?
Leading counsel, Mr. D. Pangin is out of station.
Respondents?
Lordship, I'm for the state law, Lordship, so respondent, Lordship.
So respondent.
And other one respondent is there, Lordship. One, again, respondent there. Respondent number 2 is there, Lordship.
Okay.
I'm for the
Not,
state.
not present today.
My lord,
Any objection? There. Item 24. No objection to the prayer for adjournment from the respondent. Accordingly, list the matter after 2 weeks. Yes,
item number 27 also.
7, same prayer.
Yes, my lord.
Item 27, same order. Okay. Here also, the senior counsel is not there.
Yes, ma'am.
Counsel.
My lord, can it be taken up on?
And wait, item 27, PP is there.
Yes, Lordship.
Seventh,
Yes, my lord. This second, Monday.
Monday. Accordingly, list the matter on 7th April for hearing.
May I, Your Lordship? Lordship, I beg to mention item number 23 of today's list. Leading counsel is unable to quote it.
22,
Lordship,
22 order matter.
23.
20
Supplementary hearing.
or from supplementary.
Yes, Your Lordship.
20.
23. Yes, sir.
Then who's the appellant?
That's what senior.
And on behalf of senior counsel, Mr. A.
Okay, so you have no objections on the consent of the parties. List this matter after
After 2 weeks, Your Lordship.
2 weeks for hearing.
Highly your pleasure.
Hearing matters you mentioned only hearing matters.
The respondents are yet to be filed an affidavit.
Must order when it's called out. Let it come. Let it come. We will adjourn, but let it come.
Okay. Obliged.
Anything else? Yeah.
Then, my lord, my item is item number 7.
Just wait for some time.
Your Lordship, item number 26. 26, yes. Yes, here unbody petitioner. Kindly it may be adjourned after 3 weeks. Sonnen, Majesty Sonnen.
Adjourn the matter for 3 weeks as he's out of station.
Yes, he's out of station.
Senior is out of station. Praise allowed. Yes. For hearing.
Bless.
May I, Lordship? Lordship, I beg to mention item number 19 on behalf of K. Tama. He is out of station. Kindly.
Just wait. Order and admission matters, no?
Oh,
Let's.
Your Lordship, I beg to mention item number 21 and 22 on behalf of N. Dungan.
Lordship, I like to mention item number 9. It is put up for
Don't make
bail
it the
hearing.
part one matters, huh? Only,
But the leading counsel is out of station. He comes from
okay,
Guwahati.
we'll grant the adjournment, don't worry, but let the matter come, that's what I'm saying. You just wait for your item to reach. If it's not-
Your
if
Lordship,
it's not-
kindly allow me to mention yesterday's one matter, Your Lordship, one bail application. Yesterday it was taken up.
You just go for the records, no?
It's actually, Your Lordship, it was a POXO matter.
You have to put up the, yeah,
No, Your Lordship, it was a POXO matter. The notice was issued to the victim.
yes.
Yes,
I
a POXO
remember.
matter, because notice
Ah.
has to go as per the notification as issued by this honorable.
We have issued a notice to the victim.
Oh, okay.
Yes, Your Lordship.
Yes.
Lordship,
You are appearing for,
appearing for the
For the appellant.
applicant, yes,
Ah.
appellant.
so you have to serve extra copies to the PP.
They have, perhaps, Your Lordship, they have taken steps. Now they are praying for actually, Your Lordship, TCR actually, for that,
For
they have supposed
Voting for
to
TCR.
Yes, this year.
mention for listing of the matter first.
Because the matter is not today, no?
Yes, absolutely.
So you put a mention memo and let it come up tomorrow. And then order can be
Okay,
passed.
okay. Obliged.
Obliged.
Lordship will find the FIR at the page number 19. I am apprehending
Acha,
out
put
of
the
this
whole-
FIR.
you just go to your post title. Post title. Yeah, both are-
438 of CRPC.
Yes, both are mistakes, both 482 BNS also, as well as
Yes, yes, yes,
437
actually.
IPC also.
Yes, it's a panel, they have mentioned the panel provision, not the
Penalty
procedure. part.
Provision, not
Yes.
the procedure. You refile it. Refile it.
I may be allowed to make certain corrections. If it is allowed.
This is a major error you have made. Inside also, what have you said? Under 483. And again, at para 2, you're saying 483 BNSS,
Lordship, I'll withdraw it.
all different.
Will withdraw it.
You make the corrections. Yes.
Let them withdraw it, Your Lordship, and make it correct.
I'll withdraw it.
You withdraw and refile.
I'll
Otherwise,
file.
there are many mistakes in the parallels also. Learned counsel for the petitioner is allowed to withdraw the application with liberty to file afresh.
Obliged.
May I please, Lordship? Lordship, this is an application under section 528 of BNSS, challenging the impugn order passed by the Judicial Magistrate First Class Palin, Camp Palin, Karadadi district. Lordship, the fact of the case is that, Lordship,
Where is the impugn order?
that is page number 169, annexure 4. Lordship, the respondent number 2 and 3 has filed an FIR against the petitioner number 1 to 24. There are 24 petitioners in this case. And they have also committed mischief and criminal trespass in their ancestral land. Lordship, upon receipt of this complaint, the investigating officer has carried out investigation, and after completion of investigation, the IO of the case has filed a final report that is on 13/12/2022. That is, Lordship, page number 60.
60.
Yes, Lordship. Lordship, this is, has the Lordship got it?
Yes, page 60.
This is the final report in respect of FIR number 20/22 dated 17/12/2022. A final report. No- Further, during investigation, the statement of the complainant could not be established as no any independent witness has turned up to give evidence. Further, the case is purely civil in nature and no criminal angle was found during investigation. Therefore, since the case pertaining to the land dispute in between the two clans, I am inclined to return the present case into final report, FR. Due to lack of evidence, the Honorable Court may pray for exonerate the accused person. Therefore, under the above mentioned facts above, I return the case into final report by Palin PS case number 9/23 dated 2/6/2023, as the case could not be established due to lack of evidences. Lordship, this is the first final report filed by the investigating officer before the Judicial Magistrate First Class Palin. However, Lordship, when this final report has taken up, the cognizance was taken up by the learned trial court, Judicial Magistrate Palin. The learned trial court has not accepted the final report, and therefore, thereafter, the learned Judicial Magistrate Palin has again redirected for further investigation, and accordingly, Lordship, may come to page number 121.
121. Okay. So it was reinvestigated.
Yes, Lord. It has been reinvestigated, and Lordship, after reinvestigation, same section, same case, Lordship, same informant, Lordship, here again, after due investigation under section 173 CRPC, the investigating officer has filed the final report before the learned court of Judicial Magistrate First Class Palin by final report number 11/24 dated 3/6/2024. That is section 2427/447/506/34. Lordship, here I'm again reading the relevant portion. During my PO revisit, there was no any sign of burn seen or found, and also damage of valuable trees and other but found one cement post pillar where the notice board was installed, erected by the alleged accused person, but notice board was removed very quietly by the alleged accused persons after lodging FIR at Palin police station. As stated by the complainant, photocopy cement post pillar enclosed. During my PO revisit, the complainant Sri Rugu Paching Talang shown me a big stone which called in a local language Lagna Hango. The Lagna Hango is a traditional boundary of Sango and Ray village which still exists. Photo is enclosed. During my PO revisit, I found two little huts under Sango village jurisdiction construction by the alleged accused person under the scheme of Pradhan Mantri Awas Yojana PMAY Modi Gar in local language without constant knowledge of the complainant, photo enclosed, but the said hut was constructed much later of the case and also found fencing erected at the entry point of the Sango village by alleged accused person, photocopy, fencing, and again, Lordship may come to page number 120. One and Boa 2 disputed land in this case is the ancestral land of Paching clan. Though there is no any documentary evidences to substantiate their claim or to prove otherwise, it is a fact that the alleged person have entered in the land disputed plot of land as they have also claimed the same as their inherited ancestral land. Those in the instant case, both the complainant's claim and the accused person's claim are assertive claims and the land in the dispute as their ancestral land, but both the parties failed to produce any documentary evidence in support of their respective claims that there is no any witnesses who have seen the accused person cutting down any trees in the disputed area, nor there is any concrete evidence to offense under 506 of IPC. That in absence of the evidence to prove any alleged criminal act on the part of accused party, this case evenly fall under the land dispute in between Paching and Tanyang, that is Ray clan, and hence the case is purely civil in nature. Therefore, under the above mentioned facts and circumstances, I am inclined to return the case into final report by FR number 11/24 dated 3/6/2024 on the ground of lack of evidences. The court is earnestly prayed to kindly direct the concerned authority to take cognizance of the matter at the earliest and to proceed the case under section 145 CRPC to prevent any kind of law and order situation likely to be arising in future in between both clans related to the disputed land. Lordship, here in this case, even after re-investigation, the investigating authority, the different IO has been given to carry out the investigation. But despite of investigating twice, the IO has established that there is no any criminal angle has been made out in the case. This is purely a title dispute, civil dispute between the petitioners and the respondent, Lordship. However, if there is any encroachment of the land, even the investigating officer, they have during their investigation has directed the complainant to produce the title documents, that is land document, LPC or any document, but they have failed to prove that.
We will issue notice at this stage.
Lordship,
Accepts notice
yes,
for
Lordship,
state.
in the meantime, Lordship, since the learned trial court has issued someone to the prosecution witnesses without any evidence in this case, Lordship may kindly stay the impugn order till the returnable of the notice, Lordship.
No, we are not impugn order, but we can stay further proceedings.
Yes, Lordship.
You have seen the report, so prima facie, it appears there's no criminal case.
Yes, Lordship.
And even 145 CRPC, it's to be taken by the executive
Yes,
magistrate.
that is by the
Not-
executive
not
magistrate, not by the judicial
by the
magistrate.
judicial
Lordship.
magistrate. Would learned counsel for the petitioner, Sri such and such. So, learned counsel has drawn the attention of this court to the impugn order.
That's 7/3/25.
Order. MFC. Palin, right?
Yes, District
MFC,
Karadadi, Camp
Palin,
0.
Camp 0. Whereby the petitioners have been summoned.
Lordship,
Petitioners,
actually, the charge has been framed against the petitioner.
wherein the charge has been framed against the petitioners and the prosecution witnesses have been summoned. Stop. It is the case of the petitioner that the case is purely civil in nature. And hence. it
So
is-
moreover, Lordship, all the sections are compoundable in nature also.
Acha, acha, Anyway, we won't say that now, we'll just say that the case is purely civil in nature and hence the present application under section 528 of the BNSS has been filed, praying for quashing of the said criminal proceedings. Stop. Notice on behalf of the state respondents is accepted by the learned PP. You are additional PP or PP?
Lordship, I'm for the state Lordship, 2 and 3, there, Lordship. I'm additional public prosecutor.
PP for the state respondents. So, the petitioner shall take steps for service on the respondent number
2 and 3.
2 and 3.
2 and 3 by registered post with AD within 3 days. List the matter after 3 weeks. In the interim, the proceedings of the GR, is it
GR case number 1/23,
GR case number 1/23.
PR case number
in
1/.
PR case number 1/23, corresponding to Palin PS case number 20 of 22
Lordship.
is stayed till the next regional date.
Lordship.
Right,
Date of
Lordship.
action.
Yet to file an affidavit in reply, my lord. So therefore, this matter may be fixed
Affidavit in
after,
reply.
yes, affidavit.
Who's appearing for the petitioner?
Yes,
You
yes, my.
and respondents are not there. Learned counsel, such and such appears for the petitioner and has submitted that the respondents are yet to file the affidavit, are yet to file the reply objection affidavit. So list the matter after 2 weeks, okay?
Yes,
List the matter after 2 weeks.
and my lord, there is an interim, so interim may be continued.
The interim order passed earlier shall continue till the next date.
Much obliged, ma'am.
Yes. Here for petitioner.
Yes, Lordship.
Service
Services complete, Lordship, in respect of respondent number 2.
who's appearing for respondent 1 and 2?
For respondent 1, Lordship, PP is there.
PP, yes. And respondent 2,
Respondent is yet to appear,
yet
Lordship.
to enter appearance.
Yes.
Service report awaited, service report awaited. Learned counsel for the petitioner is present. Learned should be is present for the respondent number 1. Quiz note dated 21/10/24 indicates that service report in respect of respondent number 2 has been received through email from the district judge, Lakshadweep. So, however, none appears for the respondent number 2 when the matter is called. Accordingly, place the matter after 2 weeks, awaiting the appearance of
Lordship, interim order is there.
interim order passed earlier shall continue till the next.
My lord, here the respondent and the plaintiff before the learned court has filed a suit for declaration and permanent injunction, title suit number 3/2024 on 19/11/2024. Thereafter on 20/11/24, the case was put up, and after hearing the case was admitted. Thereafter, my lord, notice was issued. My lord will find the order, impugns order at 124.
Interim order is 1.
24 was,
No,
sorry, my lord.
124 is your petition.
So it's in 147, Your
One-
Honor. FAO.
147, 147.
7.
My lord, I'll just read the relevant portion only. The learned counsel so and so represent the applicant to the case is listed for appearance of the respondent and hearing. Before that, my lord, before this, my lord will kindly come to 142 before this. This is the order passed on 21/11/2024. Here, my lord, the respondent, they have filed an application, civil miscellaneous case number 0/20/09/2024 in title suit number 0/03/2024. And thereafter this miscase application was admitted. Thereafter, the plaintiff was directed to take steps, and next date was fixed for appearance of the respondent on 27/11/2024. And my lord will kindly see the Dasti service is also allowed. The plaintiff also take service notice through electronic means to the defendant. And on 22/11/2024, my lord, annexure number 3, the one person named Tara Navam, my lord, the court below directed the plaintiff to take the step to the defendant. But here, the plaintiff has not taken any step. This one person named Tara Navam, he has sent a soft copy of the injunction application along with the document and the plaintiff title suit to the all the dependent who are the petitioner report here. Now in the soft copy sent by the WhatsApp,
Dusty service is allowed, plaintiff allowed. to serve
plaintiff was
notice.
directed to take this step, but here the plaintiff has not taken the step. Here the some other person who is not nobody in the entire issue, he is taking the step, and the step was only the soft copy of the injunction application and the title suit and the document, and the order copy of the court was not enclosed, and the notice was also not enclosed. The notice from the court was not sent. When to appear, for what to appear, it was not sent. So the petitioner were not known who has sent this, because he is not the plaintiff. And thereafter, my lord, this is the screenshot of the WhatsApp application. And my lord, we'll find page number 47 is the impugned order.
Page.
The learned counsel so and so represent the applicant. Today case is listed for appearance of the respondent in hearings. None of the respondent are present. And my lord, we come to page number 8, 157. Operative part of the. Having considered the discussion made above, this court is of the considered view that the applicant has made out a case to grant injunction. Accordingly, the operation of impeachment order dated so and so, by which the applicant was removed from the post of president, and reference number so and so 21/9/2024, by which the respondent number 17 was appointed as acting president, are stayed till final disposal of the suit number 03/2024. With the above direction, the miscase number so and so is allowed and disposed of. My lord, here the petitioner number 1, the ground of appeal, my lord will kindly see.
So what did the trial court say about the notice?
They have
Trial court
placed,
said that notice is complete.
yes, but notice they have misled the honorable court below by showing that they have taken the step upon the respondent, but the plaintiffs have not taken the step. They have also admitted they have no objection to this also, and they have made some paper publication, and in the paper publication also all the member of all Arunachal Pradesh Student Union was member was directed to appear, but they are not party in the suit also.
WhatsApp message, screenshot of WhatsApp messages sent respondents and newspaper cutting of notice
Yes,
issued respondents in the local newspaper. So it was published, substituted summon. But
they have
then court
they
never allowed for substituted summon. Court only said dusty service and to serve through electronic means.
yes.
But court never allowed for substituted summon for publication.
For substitute, even for substitute submit also, they have to file a petition under order 5 rule 20.
That's why. Then how, without court's permission, they have filed this newspaper notice? Anyway, yeah, then what else?
And even the notice from the court was not enclosed, was not sent. And my lord, the order dated 19/11/2024 an order dated 21/11/2024. These two order was also not sent. Even if the notice was not sent, but if this was sent, then they could, the petitioner would have known that matter is fixed. But they deliberately, they mischievously, they have not sent this. And most importantly, plaintiff was directed to take the step. But here in this case, plaintiff has not done anything in this case. One person out of blue, nowhere, he has sent some document regarding the injunction application and document and plaint. With that too, without annexing the order copy of the order copy passed by the learned court. No order was sent and no notice was enclosed.
So you are aggrieved by this ex-parte here,
Yes,
which was passed without notice to you.
without considering this aspect, my lord. They have misled the court. So we are framed for setting aside and causing the impugned order. So we have a good case.
You like me? Yes.
Yes, Your Honor, I'm for the sole respondent, Your Honor, here. So cutting
Yes, sir.
short, without going to merit of the FAO, their only prayer is to set aside the order date, impugned order dated 27/11/2024.
Yes.
Their prayer may, let lower
That's why
court
I'm
may,
saying, let it be remanded back.
yes, let lower court may be decided.
Let it be remanded back.
Yes, yes,
We'll
it may be
quash
remanded.
this And let the learned trial court pass order after hearing both the parties.
Yes, yes.
Okay.
I have no objection.
Yeah, please read. This is an appeal under Order 43, Rule 1R of the CPC, challenging the impugned order dated 27/11/2024, passed by the Learned Court of Civil Judge Senior Division, SEPA, East Kameng, in civil miscase 94, arising out of title suit number 3 of 2024. So, heard learned counsel for the petitioner, for the appellant, Shri, just give your name. Learned counsel,
Yes, Sunil.
you write his name or letter.
Yes, Sunil.
Learned counsel for the appellant is agreed, has a limited prayer in this appeal, stating that he is aggrieved by the impugned order dated 27/11/2024, which is at annexure 5 of the appeal memo, wherein the learned trial court has passed the order of injunction without passed the ex-parte order of injunction without hearing the appellant. Stop. It is submitted by the learned counsel that on the previous date, void order dated 21/11/2024, at annexure 2 of the appeal memo, the learned trial court had admitted the case for hearing and 27/11/2024 for appearance of the respondents. While issuing the said order, the learned trial court had directed the plaintiff to take steps on the respondents by dusty service, and also allowed the plaintiff to serve notice through electronic means to the defendants. Stop. However, learned counsel states that no such dusty service was taken by the plaintiff, and only some WhatsApp messages were sent by a certain person called named Tara Nabam, who was neither a plaintiff nor a party in the suit. So accordingly, the appellants were not aware of the fixing of the matter on 7/11/2024, and thereby the miscellaneous case was heard in his absence. Stop. Learned counsel therefore prays that the impugn order may be quashed and set aside, and the learned trial court may be directed to hear the civil mis case 9 of 2024 afresh after hearing both the parties. So, learned counsel, Sri, you are,
Mutamo po, Your Honor.
is, appears for the sole respondent,
Yes, sole respondent, Your Honor.
appears for the sole respondent, and he has no objections to the prayer made by the appellant in the present case. Stop. In view of the above facts and circumstances, this appeal is allowed. The order dated 27/11/2024, passed in civil mis case 9 of 2024, arising out of title suit 3 of 2024, in the learned, before the learned civil senior division at SEPA, East Kameng district, is squashed and set aside. Stop. The matter is remanded back to the learned trial court to hear the matter afresh after hearing both the parties. You want the fixed date to appear
Yes,
before?
yes, ma'am.
uh,
25
Uh,
of this, 25 of May.
25. It is okay with you, 25?
Could it be before that 25? Maybe
Twen-
after
twen-
second day of this April?
Why not we have to file a reply also? Could it need some more time because WS is.
They have to file a reply to your injunction application now.
Yes.
Just give them some time. 23rd, 20. Matters this.
Your Honor, there's a CRPC. CRP, there's a connected.
Yes, apart,
Yes.
apart from the other ground, there is only one ground is there. The learned court below, instead of fixing the suit for ex parte evidence of the plaintiff, they directly fix the suit for ex parte hearing of the ex parte hearing of the party. Apart from the other grounds are same.
So in this, what are you challenging?
And there's a stay in this CRP, Your Honor.
Oh, there's a stay.
Yes, there's a stay in this CRP, which the appellant has filed, Your Honor. Otherwise, there's no stay in the FOA, which was disposed right now.
Continue to the next bit. Wait. Here also impugn order is
Yes,
27/11.
the same,
Same,
yes, same prayers, Your Honor.
My lord, here also the plaintiff was directed to take the step.
Okay, you come to CRP 56 of 2024. Learned counsel for the petitioner, Sri such and such. This revision has been filed against the order dated 27/11/24, passed in title suit number 3 of 2024 by the Learned Court of Civil Judge Senior Division at SEPA, East Kameng District, whereby the Learned Trial Court, instead of fixing the suit for evidence of the plaintiff/respondent, has fixed the suit for ex parte hearing due to non-appearance of the petitioners. Stop. the order passed in FAO 6 of 2024, the this civil revision is allowed. The impugned order dated 27/11/2024 is quashed and set aside, and the matter and the civil suit, no, title suit, na?
Yes, please. Title suit number 3/2024.
And the title suit number 3 of 2024 may be fixed for evidence of the plaintiff slash respondent. Stop. The interim order passed earlier stands vacated, and the matter is remanded back to the Court of Learned Civil Justice Senior Division, that SEPA is coming district, for proceeding for evidence of the plaintiff slash respondents. Matters disposed.
Lordship, may I, Lordship, in the item two, Lordship, in today's Lordship motion, Lordship, here one prayer is that, Lordship, in the order, Lordship, the scan copy of the TSR record may be called for. Item number two,
Okay,
Lordship.
that motion matter.
Yes, Lordship. It was
Item-
state, Lordship, but scan copy of the record may be called for, yes.
Item 2, no? Motion. So scan copies of the
Right,
trial
for-
court records. may be-
Lordship,
Yes,
Yes.
Lordship. Apply, Lordship.
Lordship,
Yes.
I beg to mention one matter which may be kindly listed tomorrow. For tomorrow.
Oh, it's there. Okay, welcome.
Lordship, I'm seeking for adjournment in this
Yes,
item.
yes. What ground?
My senior, Mr. T. Tara,
Senior.
he has some personal difficulties.
Learned counsel appearing for the appellant, no? No.
Yes,
petitioner.
appealing
Appearing for the petitioner has stated that his senior, Mr. T. Tara, is out of station, and accordingly prays for fixing the matter after
On 7 Monday.
7th April,
Yes.
on 7th April. List the matter on 7th April.
Lordship, interim order is there.
Interim order passed earlier, shall continue till the next date.
Much of it.
Item 8. Yes,
My lord, can you adjourn this matter as leading counsel KW is out of station?
out of station.
Yes.
When do you want?
After 3 weeks, my lord.
3 weeks. It is mentioned that the leading counsel for the petitioner,
Yes.
for the petitioner is out of station.
KW.
Accordingly, prays that the matter may be listed after 3 weeks. Prays allowed, list the matter after 3 weeks.
Much obliged.
Item number 9. Who's appearing for the petitioner? None.
No one is appearing.
None appears for the petitioner when the matter is called for. Additional PP, Mr. T. Ete, no, is present.
Yes, Your Lordship. Otherwise, it's a POXO matter, Your Lordship, whether service is complete or not.
Service is also not complete.
Yes.
Stop. Office note dated 1/4/25 indicates that steps for service of notice upon respondent number 2, 3, and 4 is not yet taken. Accordingly, the petitioner shall take steps for service of notice and supply extra copies to the PP within the next 1 week. This is the matter after 1 week, no, after 2 weeks.
2 weeks, Your Lordship. Deeply obliged.
Item 10.
My lord, in this case, in compliance of the order passed by this honorable court on 4/3/2025, wherein I've been granted an interim protection, I have appeared before the arresting authority on 2 occasions, my lord.
Okay.
And in condition number 3, my lord, there was a direction that I shall not leave the jurisdiction of the magistrate without the prior permission. My lord, if I may,
This is pre-arrest bail.
my lord, I have been granted pre-arrest bail on
So
4/3/2025.
15 days.
And in condition number 3, there was a direction that I shall not leave the jurisdiction of the magistrate without the prior permission. Accordingly, I have filed a miscellaneous application before the magistrate. And I have been allowed to leave the jurisdiction. My statement has been recorded twice, madam. Therefore, my lord, at this stage, my prayer would be, my lord, to make the interim protection absolute, since I'm cooperating with the
Lordship, I speak for the company,
And PP.
PP. Part of a private, PPs might be having that.
Okay, call after some time.
Yes. Lordship, item number 11, Lordship. Here also, Lordship, in the course title in the paragraph number 2, Lordship, correction has to be done, Lordship.
That same mistake.
Same
Really
mistake,
like-
Lordship. Lordship, we are yet to cope with the new law, Lordship. There's some certain
No, but you're expected to read.
less, Lordship. Correct.
Uh,
I may be allowed to make.
Withdraw and
Lordship,
file a fresh.
since CD is here, Lordship, better maybe post it for tomorrow. I'll do the
No,
necessary
you
corrections.
withdraw it, you withdraw it. It's not good to make corrections in the post. You can file it by tomorrow, it's okay. Because only the course title has to be corrected. no?
Lordship.
The
And
petitioners,
CD here.
Case study, Lordship, we have called for the case study.
CD here.
it's okay, let the petitioner file a fresh.
Yes, sir, case study has also arrived, Lordship. Scan copy of the case study.
It's okay, we have already passed an order in the last item also that the petitioner is allowed to withdraw the petition with liberty to file a fresh. Yeah, this was.
All right.
Problem.
My lord, if I may take my lord to order dated 4/3/2025, passed by this honorable court.
Order dated
4/3/2025.
interim.
My lord.
Yes, 4.
Especially my lord, paragraph 9. If I may read. After hearing the submission made by the learned counsel for both sides, I have produced the annexure attached to the petition. From the FR, it is seen that the petitioner and the victim informant were known to each other for several years. And it is alleged that on 5/3/2023, he committed a sexual intercourse against the victim while staying at one of her relatives' house in the state of Arunachal Pradesh. Although the case is registered under Section 69 of the BNS, there is no averment in the FIR that the offense occurred under the pretext of false promise of marriage. Instead, it is stated in the FIR that after the offense was committed, the petitioner promised to marry her. Additionally, it is seen that the incident took place in the year 2023, but the FIR was filed only on 29/1/2025, approximately 2 years after the alleged offense. From other available documents and by both the learned counsel for the petitioner and the victim informant, it is clear that they were in a relationship for several years. Furthermore, although the alleged incident occurred in March 2023, the FIR was filed more than 1.5 years later with the allegation that the delay was due to petitioner's false promise of marriage. Thus, considering the entire aspect of the case, I find it a fit case to grant privilege of interim pre-arrest bail to the accused petitioner till the receipt of the case diary. My lord, the condition is in the last page. Last page is the condition.
Para 11.
My lord, I have appeared before the investigating arresting authority and my statement has been recorded twice, my lord. Now, this condition number 3, my lord, I have complied with by filing a miscellaneous application before the learned Chief Judicial Magistrate. Accordingly, I have placed that order, my lord. So therefore, my lord,
Yes, PP, any objections?
Lordship, yes, Lordship, at the case diary, Lordship, there is objection, Lordship. Because Lordship, as per the case diary, the accused has repeatedly evaded the investigation and failed to comply with the court direction, Lordship. And Lordship, he appeared only after availing multiple reliefs, then only he appeared, Lordship. And moreover, Lordship, this is serious in nature, Lordship. Now it is, Lordship, section under section 64 BNS and section 351 BNS, which are 64 is rape and 351 is criminal intervention is imposed Lordship. And there are incredible ground to believe the accused has attempted to manipulate digital evidence Lordship by submitting altered, incomplete, and unverifiable material. So Lordship, it is prayer is Lordship before this honorable court to impose those strict conditions to ensure the accused full cooperation with the investigation.
Well, I'll ensure I'll appear.
Moreover, the accused
See,
be mandated to cooperate, Lordship, and
When custodial interrogation is not required, there's no point.
Lordship,
Because the main intention is that the accused should be available for
Yes, Lordship.
investigation and the trial, no? We'll make it absolute. Then we'll put some more conditions. Yes.
By manipulating this here application of annex of which annex reads, let's say to Google Pay all this has been annexed by the petitioner here application from page number 54 to 80. Actually, you see the below. I admitted that in both my name is here, Arut Taba, but it's below. See, no, there is petitioner name sent by Abhishek Kumar. Here from SBI here. All this, but in their petition that they sent this money to the complainant victim. Number one. The next go to the
Chief Kumar.
here, Chief Kumar. Very carefully manipulating while they are planning this. 24.
No, but the question is, this court had given some conditions, 1, 2, and 3, and these have been complied with. There is no violation of the conditions imposed by this court. So that is the only thing which this court is concerned. Because we will not go into the merit of the case, no, at this stage.
Also, very recently, this court has, Nalik court gave us in fact, section 54 and 51. In fact, it is very clear we have mentioned that regarding the without consent, the sexual intercourse is done. And their next is in fact, it's very clear in the last paragraph that there was criminal intimidation also. That's what has been not who is this inverted because of them again this honorable court is for the prayer of the IO, one has been certain. My prayer is that
No, we will put some more conditions because even the trial court has allowed him to leave the station and then he has appeared before the IO. The IO of the case also stated before the trial court that the statement has been recorded. So whether the only issue is whether custodial interrogation is required or not. So here it appears that everything is done, statements recorded, everything. So we'll just make it absolute. Okay. Learned counsel for the petitioner, Shri such and such. J. Ring. Mr. J. Ring appearing for the petitioner. Also heard Miss
El Hage for additional
N. Hage appearing for a learned public prosecutor for the state respondent. And you are Mr. T. Topung appearing for the victim / informant. This is an application under section 482 of the BNSS, praying for grant of pre-arrest bail to the accused petitioner in connection with Itanagar Women PS case number 2/2025 under section 69 of the BNS. Stop. At the outset, the learned counsel for the petitioner has drawn the attention of this court to the interim order dated 4/3/25 passed by this court, wherein the court had enlarged the present accused petitioner on interim pre-arrest bail with 3 conditions. Number 1, that the petitioner shall make himself available for interrogation by the investigating officer within 7 days. Number 2, that the petitioner shall not directly or indirectly make any inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to any police officer. And number 3, that the petitioner shall not leave the jurisdiction of the concerned jurisdictional magistrate without prior permission. Stop. The matter was listed again on 13/3.
13-3, madam.
13/3/2025, on which date the interim order was further extended till the next date, that is 2/4/2025, and accordingly the matter has come up today for final hearing. So, learned counsel for the next para, okay? Learned counsel for the petitioner states that all the 3 conditions set by this court has been complied with by the petitioner accused, in as much as he has appeared before the investigating officer. You are saying 2 times,
On 2 times.
on 2 occasions.
On 25.
That is on 24/3/2025 and 25/3/2025. And he has also filed an application before the jurisdictional magistrate, which was taken up on 27/3/2025. And the learned magistrate, this is learned judicial magistrate first class UPIA, was pleased to allow the petitioner accused to leave the jurisdiction of the court with a condition that he shall cooperate in the ongoing investigation and appear before the IO as and when called for. So, it is accordingly prayed that the interim bail granted on 4/3/2025 may be made absolute. Stop. Learned PP appearing for the state respondents has submitted that stringent conditions may be imposed.
Keeping in mind that this pattern of non-comparison lordship and the evasive conduct and prima facie digital tampering which I have done lordship earlier, so strict condition may be imposed lordship to make the
PP has stated that in view of the seriousness of the case and also in view of the fact that there is what?
Yes, lordship.
Yes, previous.
Yeah, previously lordship, he has tampering the lordship, digital lordship, digital evidence lordship.
That in the previously there is prima facie case of the accused petitioner tampering with the digital evidence. Stringent conditions may be imposed by this court. Stop. Learned counsel appearing for the victim/informant has also prayed that in case the court is inclined to regularize the interim bail, stringent conditions may be imposed so that the petitioner accused shall appear before the investigating officer and the court as and when required. Stop. Next paragraph. This court has considered the submissions of the learned counsels, and it is observed that the petitioner/accused has been cooperating with the investigating officer till date. And it is also stated that, and it is also seen that the 3 conditions which have been imposed by this court by the interim order dated 4/3/2025 has not been violated in any way by the accused/petitioner. it is also seen that the learned court of JMFC UPR by order dated 27/3/2025 has allowed the accused/petitioner to leave the jurisdiction of the court with the condition that he shall cooperate in the investigation and appear before the IO as and when called for. So, the learned trial court also observed that the accused petitioner had appeared before the IO on 24/3/2025 and 25/3/2025, and his statements have been accordingly recorded. So, in view of the above facts and circumstances, the interim bail granted on 4/3/2025 is made absolute on the same terms and conditions. So, if the petitioner/accused violates any of the conditions set forth by this court, it may be deemed as a violation of the interim bail so granted, of the anticipatory bail so granted. So this matter stands disposed.
Okay, all right.
Item 12.
My lord, this is 2016 matter, my lord.
But
In earlier, my lord, the respondent was represented by state of council, my lord. However, they have withdrawn their name, my lord. Since then, I have,
you are for the petitioner.
I am for the petitioner, my lord.
What's happening to the notice on respondents?
My lord, as per office note, my lord, it has been, it has reflected that it is returned unserved, my lord.
Returned unserved,
Yeah.
yes. With the note that the addressee has moved. Incomplete address and addressee has moved.
Yes. In this case, my lord, I may be allowed to take by Dusty, my lord. Dusty serviceman.
Okay. Learned counsel such and such appears for the petitioner. The office note dated 3/3/2025 indicates that the notice on respondent number 1. What about 2 and 3?
My lord,
All incomplete.
yes,
Yes, on respondent number 1 has returned back with the remark incomplete address, okay, within inverted commas, incomplete address. And the notice on respondent number 3 has also returned back with a postal noting addressee moved, that also in inverted commas. There is no return of notice on respondent number 2. Accordingly, the petitioner shall take first steps for service on respondent number 1, 2, and 3 by Dusty mode, and thereafter file an affidavit to that effect. Please the matter after
3 weeks.
After 3 weeks.
All right.
Maybe George Worship. They make a seat and notice of the
Here also notice.
for respondent of 4
Yes.
is in unserved in several attempt
You were supposed to take steps after ascertaining the proper address of respondent number 4.
Actually, Your Lordship, no such type of address is found. And already the claimant and the other respondents are here.
Appearing. You're for the claimant.
Your Lordship. I'm for the respondent 1 and 2. Your Lordship. Your Lordship, this appeal petition was purely allowed on the basis of payment of the 50% of the claimant amount. And they have failed to pay the amount till today. The order was passed on 19/8/24.
Not get deposited.
Yes, it has been stayed by this honorable court. The execution was passed on the 31/5/23.
Staying of execution of the. Under the applicable insurance companies.
They were supposed to deposit 50% amount of the claimant in the registry.
We are already deposited earlier, Your Lordship. And on 13/11,
Yes, it is stayed subject to deposit of 50% of the awarded amount. So you have
yes,
deposited.
we are already deposited in the registry, Your Lordship.
When? Five twelve. Registry has received demand for, they have deposited on 5/12.
5/12.
Yes. 5/12. Respondent number 4 is what, vehicle owner? Or driver?
Driver.
Driver. Can we proceed without the respondent number 4? You are representing 1, 2, and 3.
Yes,
1, 2, and 3.
Lordship.
Did the respondent number 4 appear in the trial court before the tribunal?
Yes, Your.
Yes.
They are
Yes, they have
participating in
they
the
have
case.
appeared before the honorable member MSCT
MSCT.
Basser, and they have deposited all the required documents, the valid driving license, and valid all the required of the form 54.
And filed all written
Yes,
statement.
they have
everything.
complied, and the court has heard the matter also.
Okay, then
They have considered the documents.
has the court called for the LCR?
No.
But I think we should give one more chance, no? To the respondent number 4. Short time. But then again, if you're not able to find the correct address, there's no point. Okay, we'll admit it. Third learned counsel for the appellant. It is stated that this court, by order dated 4/2/2025, had directed the appellant to take first steps for service of notice upon the respondent number 4 after ascertaining the proper address of the respondent number 4. However, learned counsel for the appellant states today that they are unable to get the correct present address of the respondent number 4. This matter is pending since 2023. So accordingly, the matter is admitted for hearing as the respondent number 1, 2, and 3 are represented. Call for the trial court records from the Court of Member MA City, Alo, West Siang District, Arunachal Pradesh. Stop. List the matter on receipt of the PCR.
Your Lordship, we have deposited the amount on 3/12/2024, amounting rupees 15,15,203.
Okay, yes. The appellant has also deposited the amount of 50%. This is 50%.
50%.
50%.
Has deposited 50% of the amount awarded amount by demand draft on 5/12/2024 as directed by this court. This after receipt of PCR.
May I please, Lordship?
Yes.
My Lord, I am in item 14. I am for the petitioner here in this statutory appeal. So in this IM, my Lord, the respondent number 2, on the last occasion, the respondent number 2, that is the insurance department, they took time to file their objection. So till date, they are not filing any objection.
Your Lordship,
What happened? Yeah.
I'm appearing for respondent number 2, insurance, for the insurance, and due to some pressing problem, I could not file the evidence in opposition. So kindly allow me to file the same within 3 days.
Okay.
And my Lord, one more thing.
Yes.
The response regarding respondent number 1, the service report is still awaiting regarding item number 14.
Respondent number 1.
Yes.
Okay. You've taken steps.
Already, my Lord, service report is awaiting.
Learned counsel for the petitioner has not yet taken first steps. 1, 4. No service report received in respect of respondent number 1. Learned counsel for the petitioner states that the respondent/insurance company is yet to file its objection to the present application. Stop. It is also stated that he has taken steps for service on respondent number 1. Stop. Office note dated 1/4/2025 indicates that no service report has been received in respect of respondent number 1 till date. Stop. The respondent 2/insurance company is directed to file their objections within
3 days.
within 3 days. List the matter after 1 week, awaiting the service report on respondent number 1.
Right. And my Lord, item number 15 and 16, it is also a similar matter, my Lord. It is arising out of the same accident, my Lord.
Okay, same order.
Same order, same incident, and in these 2 items also, 15 and 16, the insurance also taking time, my Lord, for filing a
To file objection.
Yes,
Okay.
ma'am. Similar order.
Okay, so all together you file.
Yes,
Okay,
sir.
so same order. Till
And my-
13, 14, and 15.
Yes.
And there also.
No, ma'am.
Yes.
14, 15, and 16.
14, 15, and 16.
Yes. And these 3 items may come together, madam.
Yes, yes. And the 3 items may be listed together after 1 week.
Obliged.
Lordship, I'm for respondent number 1 in 15 and 16, and we have already filed the objection.
Yes, my Lord, we receive it. We already received.
Okay. Then we have said that the respondent number 1 is not appearing now in the order. So you just change that one, huh?
Not in 14, only in 15 and 16. Yes, Your Honor.
In 15 and 16, the respondent number 1 is represented Why it's reset as such? You're also filing your objection?
No, already filed.
Already filed?
Yes.
Okay.
Obliged.
Obliged.
Yes.
May Lord, the present applicant has filed his petition
Yes.
under section 482 of CRPC to what's the proceeding against him in TCA case number 2 of UPA, Special Court UPA. Now, here in the case, the core issue of the case has not been discussed. Now, the core issue of the case is that whether the magistrate can take cognizance, the judge can take the cognizance of the offense in the charge sheet submitted by the police where invalid sanction has been attested. Invalid because the present applicant is an IFS officer, that is All India Forest Service. He is Forest Service. Since he is a Forest Service in the Union of India, the state government has not competent to give the sanction order.
Procedural sanction.
Now my contention is that in the one of the impugned order, which I have challenged in this case, is I have filed additional affidavit. Additional affidavit, impugned order is Annexure 8, page 67, in continuation to my writ petition.
Which?
Additional affidavit.
Yes, I've seen the
Now,
additional.
now, the case is taken up today, that is 26/7/2023. 67.
Page 67.
Page 67.
Okay.
Yes. The
Order dated 26/7.
67.
Yes.
This case is taken up today for the first time before this court on being received of charge sheet from the OC/PS SIC PGN Itanagar. After paging the charge sheet and relevant document therewith, this case is taken into cognizance. Now, my contention here in the case is that in the main case, the main challenging is Annexure 3, page 41. Page 41. This is the
prosecution sanction order.
Yes, this is the sanction order. Now, this sanction has been granted along with his RFO, Range Forest Officer, Rin Mulom, and SB Abo, DFO. SB Abo is a
petitioner is Bengia
Abo.
Abo.
Now, after that, my lord, this prosecution sanction is granted by incompetent person. I am not the employee of the state cadre. I am the employee of the central government. Now, in spite of that, my lord, we are not disputing whether it is this sanction was issued by incompetent authority or not. We can see it in the Annexure 6, page 61. Page 61. Mrs. K. Bagra, learned SPP, is present and has submitted that against the accused SB above. The present applicant, the IO of the case has obtained the prosecution sanction by the state government, whereas at the time of offense, the accused was a central government employee. So we are not disputing about it. Now, when you are not disputing, this sanction is become invalid. When it becomes invalid, In such a invalid sanction, whether court can take the cognizance
Against the.
because it is an invalid. In this situation, my lord, here, our own High Court, in the Indranil Boa, impugn order of taking cognizance against the present petitioner to prevent such abuse of the process of court. Now, country 21, para 21. In Catena of the decision, Honorable Supreme Court held that inherent jurisdiction under Section 482 CRPC is designed to achieve solitary purpose that criminal proceeding ought not to be permitted to degenerate into weapons of harassment. When the court is satisfied that criminal proceeding amount to an abuse of process of law, or that is amount to bringing pressure upon accused in exercise of inherent power, such proceeding can be quashed. In the case of Parbat Bhai Ahir versus State of Gujarat, 2017, HCC 641, Honorable Supreme Court has held that Sanction 482 of CRPC is prefaced with an overriding provision. The statutes have the inherent power of the High Court as a superior court to make such an order as are necessary, one, to prevent an abuse of the process of any court. Otherwise, to secure the end of justice, same are the power with the High Court, when it exercises the power under Article 226 of the Constitution. Now, as per the order dated 10/2/2025, here, here, they have been, court had the here, Mr. O. Para learned special PP SIC vigilance by placing the communication dated 1/10/2024 submit the prosecution section respect of HB above, then DFO of Andorra. Prisoner has been sought. However, SIC vigilance is yet to receive any information from the department. If they will punish the sanction order, there will be a new course of action. But he has taken the cognizance on 26/7/2023. So that irregularity cannot be cured by obtaining of the new prosecution set. Therefore, the process which is issued for attending of the accused to the trial court the process may be set aside as what?
To whose appearing?
My
Okay. Please.
my lord, the basic question is, my lord. In fact, I admit that, my lord, during the filing of the charge sheet, my lord, the prosecution sanction which ought to have been shot from the central government was shot from the state government. It was a wrong sanction. And it was wrongfully, the court had wrongfully taken cognizance, my lord. And that was really pointed out by the special public prosecutor who was appearing in the trial court. So thereafter, my lord, in fact, if I'm not wrong, my lord, the entire process has been stayed by this honorable court. But the question is that, my lord, just because the honorable trial court has taken a wrong cognizance, my lord. Can the entire FIR and the proceeding can be questioned? No. In my humble submission, no, my lord. At the max, what happens, my lord? The proceeding can be straight. And now, my lord, on the last occasion, my lord, I have submitted the status report, my lord. Wherein, my lord, I have, it was placed on records, my lord.
You were granted
That's
2 weeks time to obtain instructions.
Yes, we have eastern
regarding the
obstruction.
Sanction.
Yes, my lord. And now, my lord, the present status is that, my lord, we have already returned to the, since we are the prosecuting agency, my lord, we have returned to the vigilance department, my lord. And so we cannot give the prosecution. It has to be given by the.
By the central.
Yes, surely, my lord. Therefore, we have returned to the conservation of forest, and what, as per my instruction, my lord, they have sent a new prosecution sanction to the central government, my lord, and we are still awaiting it, my lord. And the next, my lord, the proceeding can be stayed, but how can the entire,
This court has already stayed, isn't it? Proceedings
if I'm not wrong, my lord, if I'm not wrong, if my lord sees
in
the,
that case, it is listed for hearing.
yes, my
But
lord.
TCR has come. TCR has
No,
come.
no.
We'll call for the TCR
Yes, my lord.
also.
And moreover, my lord, the respondent number 2 is yet to appear, my lord.
Respondent number 2. So
Yes,
you
my lord.
My lord, there also one more ruling. I'm fine.
No, we will listen for hearing. And in the meantime, let the interim continue.
Yes.
Yes, the order dated 24/6/24. Heard learned counsels for the parties. The matter can be listed for hearing in usual course. Call for the
Scan copy.
scan copy of trial court records from the court of
Special Judge UPS.
Special Judge, what, PC Act?
PC Act, my lord.
Special Judge PC Act, UPIA. And the interim order dated 24/6/2024, staying the proceedings of the case before the learned trial court shall remain, shall continue till the next date.
Oh, bless me.
Next day.
In usual course, hearing in usual course, or you make it like after receipt of the decision. They said for hearing after receipt of the decision.
I'm representing the respondent, sole respondent. So this step I have not received any copy. However, by seeing the cost list yesterday evening, I have been engaged. Today, this morning, I filed a bakalatnama.
So you want to file any objections?
Yes. I will file affidavit in opposition. So
Learned counsel, Sri such and such. Interest appearance. You have filed your bakalatnama.
yes, this morning I
Interest
filed.
appearance on behalf of the sole respondent, and he has filed his bakalatnama today. Of course, it is not on record. Accordingly, the respondent is given how much time?
2 weeks.
Given 2 weeks time to file his affidavit in opposition. List the matter after 2 weeks.
All right.
I follow this lordship. In the last period, there's an interim order. Then
Check.
we will continue.
Last, the interim order passed earlier shall continue till the next date.
Yeah, Lordship. Lordship, I'm on behalf of Mr. K. Tama. He is out of station, Lordship. Matter may be fixed on 7 May.
15, no?
Item 19.
Item 19.
For orders, Your Lordship. 19.
You are mentioning on behalf of
K. Tama.
K. Tama.
Respondent.
Respondent number 2.
The mention is made on behalf of Shri K. Tama, counsel for the respondent, for adjournment on the ground that the concerned learned counsel is out of station. No.
I'm for
no
the
objection.
petitioner, sir.
Okay.
Petitioner.
Shri such and such appears for the petitioner. Learned additional PP. They appears for the state respondents. At least the matter of the
Lordship, on 7th of May, Lordship.
7th
7th of May.
May.
Yes, Lordship.
This is the matter on 7th May.
My lord, here the service is not completed as per the office note. Same petitioner, but different FIR.
By office note dated 1/4/20.
Service report in respect of respondent 2 not yet received. Office note dated 1/4/2025 indicates that a service report in respect of respondent number 2 has not been received from the OC of Namsai PS. So the parties are represented by the learned counsels. List the matter
On 7th,
Upon-
Lordship, 7th of May.
on this one also.
Yes.
List the matter on 7th May 25.
Await for service report.
Awaiting service
Your
report on
interim order
respondent
is
number
there.
2.
Interim may be continued.
Interim order.
Yes, Lordship.
Interim order passed earlier shall continue till the next date.
Obliged.
21 and 22, Your Lordship, is a connected matter arising out of same FIR. So that both the matter may be taken up together, Your Lordship. Here we have received the case diary, Your Lordship. However, today,
Lordship. Here I am representing the complainant, informant.
Respondent.
So, respondent. Today only I am
Your
doing my
entering
first
appearance.
appearance. Yes, sir. By this morning only I have filed my wakalat now.
Learned counsel, Shri such and such,
Yeah, Lord.
has entered appearance on behalf of the respondent number 2 and has filed his Vakalatnama today. So accordingly, list the matter after
Maybe 3 weeks.
2 weeks, and the learned counsel for the respondent may file their affidavit in opposition if so advised.
and Your Lordship, this may be reflect, Your Lordship, case diary may be written and
It's with you, no?
yes, Your
Scanned
Lordship,
copy.
it's original one, Your Lordship. This may,
Original.
yes, this may be written and same may be called, updated, may be called for, Your Lordship.
Otherwise, you can ask for scan copy, no?
Yes, Your Lordship. Your Lordship, from if the order is passed by this honorable court, then it will be better, Your Lordship.
Let them keep the original.
Yes.
Learned additional PP states that the original case diary has been furnished to him. Accordingly, on the next date, the PP may be furnished with scanned copies
Yes,
of the case
updated.
diary, updated scanned copy of the case diary, and the original will be returned back to the IU.
Yes, sir. Deeply obliged.
It's your right. Section 21 and 22.
22 also.
Same.
Same.
Obliged.
It's your right.
Okay, you have pulled down this picture.
In connection with filing case number 8 of 2025. Before coming to the affair of the case, I would like to highlight the facts of the case. I need page number 3 and paragraph 2 of my application.
Okay,
Marriage.
yes.
The brief of the case is that in the year 2013, some villagers of Manya village illegally encroached into the ancestral land of such and such located at Yomi village, and there were dismantled and destroyed memory, store memory, which was left in living memory of ancestor para, namely such and such. Again, in the year 2022, the said villagers carried out cardamom cultivation in the said land and started timber logging. Again, in the year 2024, the villagers of the Mednia village illegally encroached into the ancestral land of late such and such under the jurisdiction of Nyomi village. Therefore, on the 30/12/2024, all the descendants of late such and such jointly filed a first information report against the enclosure before the Kali police station. However, the case was transferred to Additional Deputy Commissioner Kali on the ground that the dispute is civil in nature, and the Additional Deputy Commissioner directed both of villagers to maintain peace and status quo of the matter, and the matter is still pending. On 13th, first affair was lost on 13/12/2024. I have annexed the affair in page number 12. Page number 12.
Where your name appears?
Your Honor, this is the first, this affair was not registered.
Okay.
And after that, Your Honor, the villagers from the Medina village again encroached the land again and again. And on 26th of this month, there was a clash between two villages. And your
26th of last month.
Yes, this month.
Today,
Yes,
today is
last-
only the second.
last-
Yes.
Well, can you see the affair at case number 19, and the type is at page number
Page
24.
19.
Page number type of is page number 24.
Page 24. Not 24. I think it's 26. In my copy, it's page 26. Because page 24 is a completely illegible document.
In my maybe 26 maybe.
First information report, isn't it?
Yes.
First information report under section 173 BNSS.
No, well, this
District Kara Tadi. This one.
type of type of
Annexure.
annexure D.
Annexure 3. Oh, acha, okay. Type copy. Dated to the officer in charge, dated 27/3.
Yes, may I read?
Yes.
To the officer in charge, Palin Police Station, District Karaya. Affair against Mr. Taha Tagru, Mr. Son of Led Tagru Tari, Mr. Takap Tagru, son of Tagru Siki, Tagru Tame, son of Led Tagru Siki, Tagru Suros, son of Tagru Siki. Madam, this is the applicant, Tagru Suros. And
Son of Tagru Siki.
So and so.
But here it says son of Tagru Siki. In your application, it says son of late Tagru Tasar.
Madam, here the father's name was wrongly mentioned as Tagru Siki. He is the son of late Tagru Tasar.
Okay, then.
And such forcefully entering the land of the victim as named below at the nomi under 30 circle with loaded gun and machete in army dress on dated 26/3/2025 at around 8 AM and blindly without any provocation opened fire and wounding the innocent person, namely as a list of 6 victims of this death. Who all have suffered grievous injury, both internal and external, with left and cut and local down in whole body part on dated 26/3/2025 at around 8 to 9 AM. And here the time is 8 to 9 a.m. At Yomi area under Tali Circuit, Radha district, leading to the airlifting of the said person in Trims Hospital at Nalagarh in very critical condition. Respected sir, with reference to the subject cited above, it is to inform that on dated 26/3/2025 at around 8 a.m. above mentioned person have forcefully entered the land of victim with loaded gun and knuckle down. And I mentioned against 6 victims. That the guns, firearms, and initiative for the brutal attack and prevent injury of the aforesaid victim were intentionally supplied by Mr. such and such and such. To all the aforesaid person whose name are mentioned in the.
Your name is here also?
No, madam. Here, not my name. All the victims are in dead weight in Trims hospitals, Nahalagan, and is undergoing serious treatment in unconscious condition. That it was a combined free-flung where murder attack upon the victim and by accused person whose name are mentioned in the subject as stated above. The earlier also that is on dated 20th December 2024, we have submitted a FIR for the police station. While in predicting the incident, as we and this person were already warned by the above stated person for such incident were, but no any serious action against were initiated by the concerned police personnel. That now our lives are also in danger as we are the next target of the culprit as per their earlier treatment. Therefore, in this regard, it is requested before your authority kindly immediate arrest or at the culprit at the earliest and register the appropriate case against them for the step above act and provide us with the security at earliest as there is a serious threat of life to us and our family members. This is the FIR. Madam, here one of the applicant on 26/3/2025, the applicant was at Itanagar. He was not at Yomi village. Yomi village is more than 200 kilometers away from the Itanagar. And my lord, kindly see page number 18. Page number 18 of my addiction. Here is the slip where the applicant refilling his vehicle in one petrol before, namely memo refilling, MS memory refilling. Kindly see the last 9:09 and 26 March 2025. So, madam, the applicant
This
was
memo refilling is at Itanagar.
So, madam, this the name of the applicant was wrongly mentioned in the FIR. However, the applicant has apprehension that he might be arrested. Therefore, my lord, this clearance bail will be put on the protect the liberty of the applicant. And moreover, my lord, there is a CCTV footage where it is showing that the applicant was present in Itanagar on the day of 26 March.
There is what?
CCTV footage.
Oh.
They attending the family meeting. So, my lord,
who's appearing? Yeah.
I'm appearing, Lordship.
You clean the CD and
Lordship,
instructions and
yes, Lordship, we have to call for the case study, Lordship, because this section is serious in nature.
yes.
And the victims are, Lordship, already in critical condition. They are admitted in the Trims, Lordship. So we have to go through the case study.
Will issue notice.
is my lord, no doubt the allegation is very serious. My lord, so but in the meantime, I may be protected because I'm still innocent in this. Yes.
That is what you say. We will have to see the CD first. This application has been filed under section 482 of the BNSS, praying for grant of pre-arrest bail to the applicant, Shri Tagru Suraj, in as he is apprehending arrest in connection with Palin PS case number 8 of 2025 under section 109 under bracket 1/118 under bracket 2/3 under bracket 5 of the BNS 2023 read with section 27 of the Arms Act. Learned Counsel, Sri such and such appearing for the petitioner/applicant has submitted that an FIR has been lodged on 27/3/2025, wherein his name has been mentioned as an accused, and therefore he apprehends arrest in the aforementioned case. Stop. The case of the petitioner is that on the day when the alleged incident happened on 26/3/2025 at around 8 to 9 a.m. at Naomi area under Tali Circle, Pratadi district. The applicant was at Itanagar and he has annexed a copy of, where is that? You were showing that gas refill page 18. And he has annexed a copy of the refill memo from the gas station at Itanagar.
So we have to ensure whether it's Itanagar or some
No,
other.
just just his submission. No,
Yes,
we have to record his submission. That you ascertain later, no? At a gas station in Itanagar, which was issued on 26 March 2025 at 9:09 a.m. to support his contention that he was in Itanagar at the time when the alleged incident happened on 26/3/2025. Stop. Accordingly, the applicant has prayed for granting pre-arrest bail in the present case. Stop. Issue notice to the respondents. Stop. Learned PP such and such, I forget your name.
That's El Hage.
M. Hage
Yes, El Hage.
has accepted notice on behalf of the state respondents. No formal notice is called for. So learned PP shall obtain the case diary and updated instructions on the next date.
Scan copy of the case study, Lordship.
Scan copy.
Yes.
Shall obtain updated scanned copy of the case diary with necessary instructions. This is the matter on, when can you get it? Next week.
Yes, next week.
9 This is the matter on 9th April 2025. Stop. In the meantime, in the event of arrest, the applicant shall be released on executing a bail bond of rupees 30,000 to the satisfaction of the arresting authority. Stop.
Then
The interim order is subject to, the interim order is subject to the final outcome of this case, which will be heard after the case diary is before the court.
So otherwise, Lordship can do less. He can appear before the IO for the statement, Lordship, if he's already.
So the thing is, on that day, we may either cancel it
Yes,
or
Lordship.
we may make it absolute. Okay,
Yes.
so there's no problem.
Lordship.
After hearing you, we can cancel it also.
This item number 29 was same. Out of 29. Same FR. And
Then why separate petition? Oh, different person.
Different person.
Different person.
Okay, okay.
So, you know,
So same ground that you were not there.
same ground.
No,
What about-
Lordship, here, Lordship, he some medical issues.
But at the same ground, I think in addition to that, is the applicant is kidney transplant patient. So there is no possibility of doing such aid by this person because he cannot go to that area.
Okay.
Same order maybe.
Okay, same submission, but the name is different, okay? Here, the applicant's name is Tana P. Tagru. And then instead of saying that he was in Itanagar and all that, you just say that the applicant is a kidney patient and therefore he could not have been at the place of the alleged incident on the said date, that is 26 March 2025. Okay. The others, rest will be same.
Lordship, obliged, Lordship.
Item number 25.
Lordship, this is a criminal jail appeal. I'm representing respondent number 2. But today,
You have received.
yes,
paper book,
yes,
no?
Your Lordship. This is listed for supplementary hearing, but appellant, counsel for the appellant is not present today. I'm for the respondent number 2 complainant.
When should we put it then? Next week or after 2 weeks?
After Bihu holiday.
After Bihu.
After vacation, Lordship, yes.
Learned counsel for the respondent number 2 is present. Learned PP is also present. However, learned counsel for the appellant is not present when the matter is called. It is stated that the paper books have been received and accordingly the matter may be listed for hearing after the Bihu break.
Obliged.
Obliged, Lordship.